to reserve any for rebuttal?
Yes.
20 minutes.
Yes.
You have 30 minutes and you're going to reserve 20 minutes for rebuttal?
That is correct.
Okay. All right, let's get started. We're going to begin with closing arguments on the on this case. I've given each side 30 minutes. This is the Moss v. Martin case. You may proceed. And Mr. White, I think, was going to start.
May it please the court. When Mr. Capua gave his opening statement to you, Judge, he referenced the movie Catch Me If You Can. He also referenced in some of his questions with, or believe in his opening statement, the image that you see with The Godfather, where you have the puppeteer and the person who is manipulating all of the various participants, if you will, like puppets on a string. Mr. West and Craig and I have all argued and debated different aspects of this case. Let me suggest to the court that, or take a moment to go back and tell you that 8 years ago, I met Mr. Keating and Mr. Moss. In 2014, I was retained by them to pursue a breach of fiduciary duty, partnership agreements, and fraud against Mr. Martin and Mr. Marco Princip. 6 years ago, in 2016, a federal court rendered that judgment on April 15th. 3 years ago, the Fifth Circuit mandated that judgment in January of 2019. Almost 2 years ago, we began the due diligence to trace the various assets that could be levied or executed upon. We traced money through Carolyn Martin's bank accounts back to Thursaz Ventures in the British Virgin Islands, which uses Von Tobel AG, a Swiss bank. This is the bank that allegedly Chrissy Martin transferred almost $400,000 to her mother-in-law when she had 1 foot out the door, so her mother-in-law could buy a house for her daughter-in-law. That very question that you asked in the beginning of this trial, and I believe that comment was made by me in the October 15th, 2020 temporary injunction hearing. I think that comment was pretty influential too on the court, because it really just defies common sense. And as a judge, you know, you have to judge people's credibility. It's just that simple. So you take into account their biases and prejudices, their motives, what have you. And of course, this case is about money, pure and simple. We're here to collect a judgment. And if we don't get the aid of the court, as Texas law requires, it makes this whole process waste of your time, our client's time and resources. This is how we resolve disputes in our civilized society. We don't pick up guns or baseball bats and go over to people's houses and say, give me your property or else. That's not how we do business, okay? And so in this case, we have played with clean hands and done everything we can according to the law to try to lawfully collect upon a judgment. And of course, Mr. Martin and his wife, Holly Martin, fled the U.S. to go to England, okay? I have real qualms about that, because I think you don't play by the rules, then you don't get the benefit of the rules. And that led to Mr. Martin, you know, he provided no real discovery in this case. He defied every court order issued when you compelled him, as well as notices to appear and show cause, okay? He put himself in that chair, as we say, if you will, when people are accused of certain criminal conduct. The defendant put themselves in that chair. Nobody else put them in that chair. Having said that to you, I believe there's another theme in this case, and I believe strongly that Holly Martin is kind of like Bonnie Parker, and Brian Martin is kind of like Clyde Barrow. I think Bonnie Parker was attracted to Clyde Barrow because he had a great car and he dressed well and he, you know, led this exciting life. And Bonnie Parker may not have known that Clyde Barrow was in the Barrow gang were bank robbers at the time. But once she got involved with them, once she started hanging out with them, once she associated with them, she became a bank robber. And she knowingly became a bank robber. And eventually it led to her death, if you will. What I'm trying to suggest to you is that Holly Martin clearly aided and assisted. And if this part, I'd like to transition into the court's charge that we provided to you. And I'm going to do this from memory. But clearly, Holly Martin engaged in a civil conspiracy that we pled with Carolyn Martin and Brian Martin. She can claim she didn't, but the fact of the matter is the evidence overwhelmingly shows, no one gets a house at the age of 20 bought for them with their mother-in-law's money after being married 9 months and having met the mother-in-law once. Okay. Now, if Mrs. Martin, Carolyn Martin, had been an Astor, a member of the Walton family, or whomever, that'd be a little bit different. But she was a teacher's aide. And while she may have some teacher's retirement, I think it's ludicrous and insulting to the court's common sense to suggest that she would give $340,000 to her newly minted daughter-in-law, who was 15 years younger than her son. It's just not plausible. After that, if you will, we alleged aiding and assisting, or aiding and abetting, which I believe is kind of, O'Connor says, and according to the restatement of tort second, insisting and encouraging. Okay. Clearly, she has assisted Brian Martin, okay, in moving these videos that are intangible, electronic, personal property. There's real property and personal property. This is simply intangible, electronic, personal property. It can be executed upon according to Texas Property Code, Chapter 41 and 42, as the court is probably well aware. It's not homestead, it's not retirement, it's not anything else. She aided and assisted in fraudulently transferring these assets that rightfully belong Brandon Keaton as a representative of Fidelismus and David Tyler Moss. In addition, our clients are judgment lien holders as described in the property code under Chapter 51. That makes them the equitable owners of all of this property. The legal owner is just the person who simply has current possession, but that doesn't mean they have equitable ownership, and equity always trumps legal, if you will, under the property code. That being the case, we proved the next cause of action, fraudulent transfers under Tufton. And we're going to be asking the court for the remedy under 24.008 of the Texas Business and Commerce Code, which the court has the inherent authority to levy on these assets. And right now, this is a permanent injunction trial, as the court is well aware. We had the TRO, the temporary injunction. Now we're seeking the permanent injunction and a final judgment. And we want to maintain the status quo. We want everything kept exactly the way it is at YouTube and Google. We want everything simply frozen until the court can enter its final judgment in this matter. Having said that to you, with regard to the fraudulent transfer, it's key to know, obviously, what the badges of fraud are. As the court knows, insiders have extra scrutiny because you trust, you're going to let the people hold your property that you don't want executed on. You're not going to just trust a stranger. You're going to trust family members and close friends, if you will. Clearly, Holly, Carolyn, and Brian are all insiders to each other because they're related either by blood or marriage. That's that. One of the badges of fraud is absconding and fleeing. Nobody made Brian Martin leave this country. He's a U.S. citizen. He gave up his U.S. citizenship in a practical sense. And Holly Martin gave up a paid-for house. There's no mortgage on that house. They paid $340,000 cash with our client's money and went to England to escape the jurisdiction of this court. Because I told Brian Martin's attorney that if he didn't answer discovery, eventually, like all people who don't answer discovery, can have their pleading struck or be held in contempt.
You've had, you've used 10 minutes. You want to keep using some more or?
I'm fine.
Just a few more. As Senator West has been
Attorney
gracious.
West.
Yes, excuse me, Mr. West is gracious enough to allow me to. We traced this money, Judge, through these fraudulent transfers from Von Tobel to Bank of America and Carolyn Martin, JP Morgan Chase. Carolyn Martin had withdrawn the money and then put it in JP Morgan Chase, and then she wired the money to Republic Title Frisco. All of these documents are before you in evidence, even if we didn't discuss them here today. They titled the property in Holly Martin's name. That brings me to the YouTube and the Google. Just like in the underlying previous federal lawsuit, there's been a similar course of conduct by Brian Martin in this case. The first thing he did in the underlying lawsuit is he did a copyright strike, which just means that there's a dispute over ownership. It's not an actual determination of federal copyright matters. It's just like calling a tissue Kleenex. It's just the generic name for that. Google does not decide who owns what. I can assure you of that. That would be supplanting or undermining federal when it came to intellectual property. Now, they took the futuristic hub, just like Mr. Martin, when he did Video Games Channel, he destroyed it overnight, and Judge Stickney had him in court the next Monday, 4 days after the verdict. And he was almost held in contempt for doing that. That's what's happened in this case with Futuristic Hub. They've transferred the content to Wildcraft and then tried to pass off this ludicrous argument that she's owned this property since she was 12 years old. That's just a farce on the court. And I think the court knows that, as she has admitted, and Mr. Martin admitted, that there's no documentary evidence of her owning anything. Lastly, we want the status quo. That's what we're asking for. We've proven conversion besides fraudulent transfer. We've proven fraud in a real estate action. And we've proven common law fraud. And we're asking the court to enter judgment as to liability on Holly Martin on all of those causes of action. And then going to ask the court to enter judgment after hearing from Mr. West in closing, regarding the actual monetary damages, and then ultimately exemplary damages. Leave you with this last quote. Potter Stewart once wrote, "He could not define obscenity, but he knew it when he saw it." I would suggest to the court, fraud is in the similar category. It's kind of hard to define exactly what fraud is. And I'm not talking about misrepresentation of this or omitting that material fact. I'm talking about when you see fraud, you kind of know it. And that's what we've proved to you. And that's what we've demonstrated in the last 72 hours to this court, is a massive amount of fraud to avoid paying on a lawful judgment affirmed by the Fifth Circuit Court of Appeals. Thank you for your time, sir.
Okay. Mr. DeVos, you have 30 minutes.
Thank you, Your Honor. I would appreciate your keeping me apprised of my time. There is some powerful evidence about my client being the originator of these videos. Her father said she started doing it. He bought her a computer to do it. Mr. Knox came over and he saw that Brian was doing exactly what the two of them had testified to, talking to her on the phone. All he was doing was rendering the stuff, that he was not doing the original animation. We have numerous documents, communications with Google, the Google documents themselves, which state that Holly Bone is the owner of these. Those documents are dated back prior to the 2019 day. I really am not sure what Mr. Wyde is saying about all of these various causes of action. The primary cause of action against my client is fraudulent transfer, in which case she is the transferee. In other words, she received assets that the plaintiffs have claimed belonged to Brian Martin. But she never received, and I'm going to assume how Your Honor is going to rule on who owned the videos, because I've seen that all through the trial. I've seen it all through this whole lawsuit. You're going to rule against it. But okay, given that, what are the damages? Well, it can't be before April of 2019, because both of them stated that every penny that came off of those videos went to Brian Martin. Now, he may owe you money and he may have spent it, but it's not Holly's liability. There was nothing transferred to her. And when you get to the transferred money, she was tricked into saying, oh, we're making, 80 to 90 since 2016. Well, the only time that her liability is going to start is going to be in the time that she took it away from Brian and gave it to the Freedom family. And I'm going to share the screen a little bit on this. And this is the document that we have, that's, I think, document 21, which shows the total amounts of money that she got from Freedom Family. There, I've total amount $926,406.42. And that's the maximum that can be
What about the money since then?
Okay, the money since then, she testified it's $30,000-$40,000 a month. It comes to about $500,000. There's no way. I don't have any records that will refute that, and that may be relatively accurate. But to say she's got $6 million of damages is ludicrous. Now, I would like to look back, and if you want, guys, I can say, well, you can put your own, put it in. I don't have the total on the exhibit, but this is what the exhibit was from, and that's the number that you get. But with respect to the money from for the house, there is no evidence that that money came from Brian. There's speculation. She didn't have much money, but Chrissy came in here saying she didn't know anything about this account, which was in her decree. There's the divorce decree. It says this is the account. This is account in Chrissy Martin's name is awarded to Brian Martin, but it's in Chrissy's Martin Lane. And the name that she used for that was this document that she signed. Can you still see that? Yes, I'm assuming it. And
I can't. Are you share screening something? I can't see.
I thought I already had it up there. Oh, excuse me. In her, just to go back a little bit to her divorce decree. See, this is the bank account. Let me go back a page. The Swiss bank account, which is in Chrissy's Martin name. She's the sole person on it. And here's how she got it. She was very reluctant to acknowledge, but she did acknowledge that these are her signatures. This is, and that they are all signatures before a notary, which she can't say that it was somebody else who signed it. And we get over here, it is her passport that she used to identify herself. This fits with Brian's testimony. She was terrified she was going to lose her money. From Mr. Knox, we found out that, she was pretty well off. She'd had 6 or 7 channels. She wasn't sure how many, but he'd looked at them. He'd seen what they were bringing in, and he said she was okay. And frankly, he said that Mr. Wide had grabbed her bank account. And I've noticed Mr. Wide grab anything. I wouldn't want to be in his way when he was heading for that piece of pizza that I wanted. So she was terrified, and she took her money and moved it across. And all the money, let's take a look at this bank account that we're talking about. It's got, there are a bunch of additions into this. Now, some of them, I don't know what they are. This one here, this AdSense, I don't know what that's from. But these I definitely know, and nobody's testified about that. But these we know, that one there, and this one here, and this one here. And Chrissy may say that she didn't send it over. She was the only one who had the ability to send that money over. And it appears to be her money. In order to have my client liable for the house, there has to be proof in the record that the money that was used to purchase her house was money that came from Brian or the channels. And there is no proof on that issue. So that liability cannot be established. The other thing is, when we're talking about, he talks about fraud and conspiracy. I mean, she can't conspire with herself. She cannot aid and abet herself, and in the statute, I got it here somewhere, Business and Commerce Code, the remedy for liability under Fraudulent Transfer Act, the judgment may be entered against the first transferee of the asset for who the transfer was made. And the way this statute works, if the money came from him, then the asset will be something to be taken back. But there's speculation, but there is no evidence in the record, either by testimony or by document, that shows that Brian's money went into this house. So, that cannot be assessed against her. This I find the notion that sweet, mild, childlike Holly Bone can be a Bonnie Parker. I don't see her riding around in the backseat. I just watched that movie a few days ago. I I don't see Brian as Clyde, but I don't know about him, but I know about her. When we were seeing those videos, which I'm convinced she makes, she doesn't remember very much about what she does. It's not the way her mind works. And you have an expert coming in who's really kind of trying to read her mind, which is not his expert. Well, she should have remembered that. She should have seen that. She should have known that. When she didn't know something, she said, I go out and I find something on YouTube and I learn something. And she is not an accomplished person. I mean, Mr. Ponzrantzis can juggle that stuff around. But she's a creative person. Her mind is not on the dollars and the cents. Her mind is on what gives her enormous joy. And if you didn't see, as I did, the absolute unadulterated joy with which Ms. Bone makes those videos, then I think you're missing something. That probably means you haven't had little kids. But that's what I see her in. She is very not worldly wise, and that comes from her testimony. She's intimidated when she testifies. She doesn't testify necessarily very accurately. She's intimidated by the entire process, as you saw what happened in her deposition. And she doesn't understand a lot of things. She cried, and Mr. Capua said, I'm not being discourteous to you. And she said, I don't know what you mean. So she doesn't know what the word courteous means. And that's a function of the way her mind works. And autistic people don't understand societal norms. Why they don't, I don't know. But I've seen that, and I think you see it in her. And you don't have to say whether she's autistic or not, but it's pretty clear that those concepts do not work for her. Mr. Wide says, well, you got to use common sense. And what I would say about my client is she is grossly lacking in what you and I would call common sense. And I think she was born without it. And I don't know if she will get it in the future. But she is, I think she is a lovely human being, and her great joy is in creating these videos and having people who look at them and enjoy them. And I'm pretty sure that the court is going to take that joy away from her. And she may or may not be reconciled to that. But I cannot see any assessment of damages beyond what she realized from the channels that were with Freedom Family and the $500,000 or so that's on top of that. The numbers beyond that are just made up. We have to look at evidence on these things, and I think the plaintiffs go far beyond the evidence. They keep trying to say that the original temporary injunction, which does not mention videos, applies to videos. It only applies to channels and to the flow of money from the channels. And we all know that channels are not videos. Those are separate entities under separate schemes of the law. So, Your Honor, I'm pretty sure I know where you're going to rule. I think I knew it from day one, but I trust that you will be led by the evidence and not by argument, inflammatory argument. Thank you, Your Honor.
All right, Mr. West, let me just kind of say this at this point. Mr. DuBose is right. I am going to find in favor of the plaintiffs in this case. What I really wanted, what I'm kind of wrestling with at this point is a couple issues, the calculation of damages, how, because I think that, there has been some compelling argument made on that. And then the issue of what is the exact remedy we're doing here. Obviously, we're turning over ownership of Futuristic Hub and Wildcraft, but what else? Punitive damages, those types of things. What other remedies are we really looking at here? And so that's what I really want you to focus on. I've heard all the evidence. You don't need to. This isn't a jury. I've been living with this case for a while. So let's kind of focus on the remedy and what is appropriate under the law.
Your Honor, if I might for a second, if we're talking about that point, in their opening argument, the plaintiffs did not mention punitive damages at all. And if that is brought up by Mr. West, I will request a little time to respond to that point. I think I would have had some time left on my 30.
Yeah, I don't have a problem with that.
Thank you.
So let's kind of go through the damages here. This is, I do find, unless there's something I'm missing. So he's arguing that you guys are arguing, I think it was something like $7 million or something. I don't remember exactly. And he's arguing it's $926,462.45 plus an additional, I calculated it's $750,000 for Wildcraft. And then the house would be, I guess, $250,000. So that would be kind of where I'm starting, but I wanted to just kind of get an idea of and I'd like to see documentary evidence. If those numbers are wrong, tell me why they're wrong.
Okay, Your Honor, we'll try to come up with documentary evidence, but frankly, what we are doing, we're focusing on testimony of Polybone. Okay, and Polybone said, in terms of money the channels were making. Okay. I know they brought a document to you, but they didn't say that this was the only account that the monies were going into. Okay. So when you look at this document, it seems the document is Defense Exhibit 21. Surely, if this was the only account that monies were going into, they would have said that. They did not say that. What Polybone said was what Mr. Capier got from it. I don't need to go back through that. You know that. So we think that's the most credible evidence and meet our burden.
Look, I may be getting, there's a lot of numbers going on here and a lot of different accounts. So there was money that was taken, I know, that was put in the registry of the court.
Correct.
And this is directed at both of you. That money that was put in the registry of the court, is that separate from the $926,462?
No, that's part of it.
Well, I don't know that it is.
It didn't.
doesn't- I'm sorry.
Beg pardon?
Go ahead. I'm sorry. Go ahead.
That's part of that because some of that money was paid out and then taken back.
There's no evidence of that, Judge, at all.
Well,
Well, I mean, we're talking about evidence. There's no evidence.
you haven't presented any evidence as to the right to the $300,000 that's in there now. It is taken to be applied to any judgment. You did not testify as to, oh, this is for separate damages. No, it was
Mr.
it's
DeBose,
part of damages.
Mr. DeBose, I agree with you. That should go towards the satisfaction of the judgment. And so,
Your Honor, how did you
I'm
get?
just trying to, I'm
Yes.
really just trying to right now, I'm just trying to calculate. And so that money was the money that was frozen in the registry of the court. And this might be best directed to Mr. Wyde because I know he was more involved in the case back then. The money that was frozen in the registry of the court, was that from Futuristic Hub?
Yes.
Yes, my clients,
Yes.
yes.
Can you show that exhibit, the $926,462 exhibit? Could you share screen that, Mr. DeBose?
Yeah. You want the document with the total, right?
Yeah,
Okay. Uh,
Defendant's exhibit.
Okay.
So
There you are. And I don't know which of these things down here were the one that they got out.
were any of the money that was frozen, Mr. White, I'm sorry, was it included in here or is it separate money?
It has to be separate money, Judge, because if you look at the dates of this, first off, you ordered that money impled into the court in the spring of 2020. And you can
Okay.
see that's after Mr. Hurst got involved in the case, if you recall.
Right.
And he got involved in December of 2020. Excuse me. Yes, 2020, if you will. That's when he got involved. So consequently, any monies prior to that were not, they were distributed, in our opinion, inappropriately to
You don't need to argue liability at this point. I've
Okay.
already
Yeah,
ruled, I ruled
Not
in
a problem.
favor of you on all those points. I'm just trying to calculate damages at this
Yeah.
point. So,
so
Your Honor will,
so there wasn't any with the registry of the court, the funds in the registry of the court didn't get placed in there until the spring of 2021.
okay, but,
no,
okay,
no,
so
that's not right.
Yes, that
Miss-
is correct.
Mr. Wide, let me ask this. And I'm just trying to figure this out because this is just really remind me if because this happened a long time ago. My recollection was the money was basically taken directly from Google and deposited in the registry of the court. It did not go through the defendant's bank accounts, correct?
Yes.
There were funds. I got to find the bank account. There was money that was returned to, I'm trying to find it, that were put into the bank accounts in England and then taken out.
And that was the
So-
money that was frozen. That doesn't sound right.
No, it was taken back out. Let me see. No. What we've got in that exhibit is what the money that went into those accounts was. And let me go back and take a look at this. It's 158.
Okay, leave this up, Mr. Wide. What period of time was the money frozen from? Was it it was like two separate payments, is that right? Or three separate payments?
December 2020, January and February 2021. And you can see that this doesn't even include, that's literally,
That's after this money.
yes,
Okay,
yes.
Well,
We also need to explain to the court, if you could, which will help you directly on damages. Defendant, plaintiff's exhibit 17, please. And if I could share screen that with you.
yeah, go ahead.
Yeah. This is frankly, the reason, Judge, exactly why Mr. Martin decided not to participate in discovery. Look at the dates of these documents. This is December 21st, 2018. This is an 80. Could you scroll it down just a tad? Right there. Perfect. Go back up just a tad, a little bit more. There you go. So $80,000, $80,502 for this is December 2018. Now, Mr. Dubose brought up the issue of a statute of limitations. There is no statute of limitations issue because we're entitled, if you will, from the date of the mandate, if you will, that the statute is told while the case is on appeal.
Your Honor,
I'm just,
if I-
no, Mr. Dubose, excuse me.
Yeah.
So there is no statute of limitations on any fraudulent transfer issues. And if Mr. Dubose thinks there is, then I would request that he submit a brief to the court on that issue.
Okay, Mr. White, okay.
if I may, Your
Wait,
Honor,
wait. I'm trying to get, I don't understand Mr. White's point at all. So explain what you're trying to say.
Well, Judge, in December of 2018, these channels at that time, Futuristic Hub was making $80,000 a month. And here's January of 2019, and it's $102,000 a month. And these are back-to-back statements. And this is basically some of the only discovery we were able to get from Google. So that's why we believe we're entitled to an average of those 2 months for 92,000.
Okay, so how does this correspond to what was in the other exhibit? So this is from December of 2018. Let me write this down, 80,000.
Your Honor, the problem with this is that my client testified she did, first of all, this is money that's going to Brian.
Excuse
It's
me.
not money that's going to
I-
my client.
I
It
object.
cannot be
I object.
possibly, none of this was fraudulently or otherwise transferred to her. It only went to him.
Mr. Dubose, excuse me. I object, Your Honor. We have 3 months, December, January, and February of 2020 and 2021, and we have almost $300,000 deposited into the registry of the month. That's an average of literally, it's 290,000. So that's an average of almost 95,000 a month. Then we provide to you corresponding or corroborating documentation of evidence right here that is from 2 years previous. This includes December 2018 and January 2019 that Futuristic Hub was averaging $90,000 a month. To suggest that these channels weren't generating all this money in the past, that's why they had to transfer all the videos to Wildcraft and get it up and running to continue to try to make it monetized. That's another fraudulent transfer of the intangible electronic property.
Okay, Mr. White, I've already ruled in favor of you on all points, so
I know.
you don't need to keep arguing liability. You're really, I'm trying to get a calculation of damages.
And Judge, this cannot
We
be her
believe-
damages. The money, if money goes to him. And no, there is nothing here that says that he says he managed a bunch of channels. I don't know, and there's no testimony in the record that says that that came from. Ms. Bone, when she was presented with it, she said, I don't know what channels that may have come from. So,
Okay.
and also it ain't going to her. It's going to him.
Mr. Dubose, they're married. It's presumed community property. The burden shifts.
Is she,
me.
no, you
Excuse me,
can't,
Mr. Dubose. Excuse me. The burden shifts for her to prove that it's her separate property or that it's sole managing community property. She's not met that burden. Proper, if you will, Judge, the proper measure of damages is $90,000 a month, 2016 from the date of the federal judgment through any other documentation up to with Mr. Dubose discusses this with his defendant's exhibit 21. So we're
Well,
entitled to $90,000 a month for those previous 3 years of 2016, the 8 months in 2016, 2017, 2018, 2019, and then up to 2020. Then we get into this Wildcraft thing, and that he's using the alleged amount of money from Wildcraft, which did not include all of Futuristic Hub's videos, monetized videos. And he's trying to cheat
Mr.
down.
White,
But-
okay, we're getting confused here. Wait,
well, if I may,
wait. Okay, let me just try. I'm trying to figure this out. So 2016 to 2019, though, there is no evidence that, I mean, what I have found at this point is that starting when the judgment really became final, which was in 2019, that's when really the fraud as to Ms. Bone started. And so the damages between 2016 and 2019 are going to be asked, those are going to be found as to Mr. Martin, and I've already found a default judgment as to him, correct?
Yes.
Okay, so we're trying to determine damages as to Miss Bone.
There's,
That's what I'm trying to
there's,
do.
yes, there is joint and several liability though. And I understand that she enters the picture in 2019, but we sued Mr. Martin and there are damages attributable to Mr. Martin and Carolyn Martin in this case from 2016 through until he gets married.
But I've already ruled as to Brian Martin. I already have a default judgment as to him, right?
But not the damages. You haven't calculated the damages, and the damages regarding the channel is what we're saying to you on average was $90,000 a month. And then when you look at when you froze the money in late 2020, early 2021, that's another 300 grand, and that's only 3 months. So, you know, again, you have the fraudulent transferee, if you will. And of course, all this is community property at this point. So they're both jointly and severally liable because it's a
My
tort.
understanding though is, I mean, this whole trial, we've basically you guys have taken the position that Mr. Martin, there was a full default judgment against him.
But we also want damages against him. I mean, liability against him is nothing. We want damages for the money, the revenue from channels. We're entitled to, under the TUFTA, we're entitled to all of the revenue. We're entitled to the revenue of the fraudulently transferred assets.
Well, Your Honor, if I may, that's if their theory is if it went to him, then it went to her, then there's no fraudulent transfer because it's community property and she's entitled to have permanent property. So that's a silly argument. Now, against Brian Martin, who's not my client, if you want to get judgment against him for that money, which he took, he spent, that's not my business. My client didn't have that money in her hands until it started going from the Freedom family into an account that only had her name on it. And
under
that,
civil conspiracy, excuse me, under civil
oh,
conspiracy,
for God's sake.
excuse me, Mr. Dubose, under civil conspiracy, they are joint tortfeasors, and each co-conspirator is jointly and severally liable for the damage caused by that conspiracy. And that is a question right out of the pattern jury charge. And that's what we submitted to the court in our jury charge, if you will. She is just as liable as Mr. Martin is when she gets involved with him in the spring of 2019.
Okay,
And
this is well beyond what I had understood. My understanding is the conspiracy really began in 2019 as to Miss Bone, that her, and what I'm going to find is that the conspiracy as to Miss Bone started in 2019 and continued to today. And so the damages as to Miss Bone will be calculated as to that. And so so that's where we need to figure out the calculation.
And we're, I apologize, but she cannot mitigate damages by trashing the property. In other words, they shut down Futuristic Hub and opened up Wildcraft, just like they had done with Mr. Martin had done with Video Games YouTube channel.
We didn't shut down.
Excuse me, Mr. Dubose, excuse me. That fraudulent transfer of that property damaged our clients. And therefore, she is responsible also for that lost revenue of the $90,000 per month that that channel was getting had they not done anything with Wildcraft. Futuristic Hub would continue to be making at least $90,000 a month, and they have no evidence to rebut that damage.
Well,
And they failed to produce any of that evidence, which is why you struck Mr. Martin's pleadings. He made the tactical decision, Judge, I'm not going to give you my tax returns. I'm not going to give you the financial documents that I got from Google. That's what led to the default judgment, because they knew they'd be better off arguing at this point this Wildcraft drivel, if you will, because, you know, that's just a stepchild of Futuristic Hub. Futuristic Hub was making $90,000 a month, and they diminished that value when they tried to fraudulently transfer these videos, the monetized videos, to Wildcraft. They should not benefit They should not benefit for fraudulent transfer of those videos. It's
Your Honor,
just
if
that
I
simple.
may, do you ever?
And he has no evidence to rebut the damages of $90,000 a month from Futuristic Hub.
Your Honor, we didn't shut down the channels.
You
They were
violated the
frozen.
TRO.
They were
Violated the
frozen.
temporary injunction.
They, now can I talk? I mean, I know you like to hear yourself talk, but please. let me do-
Violated the temporary
Mr.
injunction.
Wide, let him go.
Yes, sir.
Those channels were shut down by Google in compliance with the orders that you got, not by us. So, the fact, and my contention would be that
I
we're
don't
the
think,
great
we didn't
losers.
shut down the channels, did we? I don't think that was.
No,
wrong.
that's the
They
letter.
stopped getting money from it, but it
No,
was
that-
never shut down.
Oh, yeah, it was. It was, well, we have no access to it. It was frozen. And that was Michael Hurst's letter in April. And he said, we've frozen the accounts, the channels, 'cause that's the only way we can keep the money from getting to whoever it was going to. And that's what stopped everything. And to hold us liable for the effects of what Google did in response to an order from the court seems wrong. And
Mr. Capua informs me that from literally June of 2019 to the present at $90,000 a month, and we'd ask the court to write this figure down if you don't mind. Make a note of it. That would be $3,060,000 against Miss Bone Martin. That does not include what we believe should be exemplary damages for this farce about claiming she owns this channel since 2012. The number against Brian Martin, excluding exemplary damages, is $7,005,000. And that's from 2016 present, from the fraudulent transfer, from the federal judgment presently, which we're entitled to collect upon. So $3,060,000, excluding any exemplary damages the court would award under Tufta or conversion, and $7,005,000 in actual damages against Brian Martin, excluding any exemplary damages under Tufta or conversion.
And then what about the real estate?
Real estate, the documents before the court is that the house was purchased for right at $340,000 in January of 2020. We're asking for the purchase price of the house, and we're not going to argue about present value, even though you're talking about the hottest real estate market in the country, in Frisco, Texas. $340,000, the amount of money that was used that belonged to my clients that went to buy the house.
let me
Mr. DeBose,
just,
you're allowed to argue as to damages right now.
yeah, and this is the letter, and it's been the 4 deposits thing, and there was some in one of those records. I've got to find it. Some of the money went back to Freedom Family, which went back into this, but they I'm trying to see. Here's said they were not monetizing because Google made an error. But Google has frozen control of the channels pursuant to the court's order down here. And that's what, that's what has killed the channels. You killed the goose that laid the golden egg. So there may be some, I know there was money given back, and I'll dig it around and find the document that has that in it, because it's some very small print on some of the things from the English banks. But to assess damages beyond what she got, the thing is, the only money that was coming out of those channels was going through Freedom Family. And that's where that's what the contract with Freedom Family was about. They were handling those two channels, and they built up the income according to those two channels from $21,000 to $100,000. They did a very good job in promoting the channel and promoting the videos. But there's no evidence of any other income coming out of those videos that's in the record.
Madam Mayor, if you can respond, cool to take judicial notice of the fact that issue an order in terms of a garnishment to Google, in terms of, I guess, as all of us, that the monies that were going to be dispersed in March should not be dispersed pending this particular case. So there are additional dollars that are coming out there. I think, can I finish, sir?
Oh, yeah.
Right. I think that Mr. Hurst has said, and correct me if I'm wrong, there was about $600,000 that they still had that they have not dispersed. So there are dollars that are still being dispersed.
Well, those dollars are not dollars we have. They're not dollars that can be put into the damages. You may be entitled to those money from Google, but my client certainly is not entitled to responsible because she's never got them. And the money that's going into the account now for Wildcraft, she's not getting that. There's no fraudulent transfer when she doesn't get the money.
Your Honor, the reality is that if we hadn't put that order in place, she would have gotten it. Okay, and that's part of the damage. Can I finish, sir? That's part of the damage model that we had, taking into consideration monies that should have been given to our clients as a result of the fraudulent conveyance and conversion and everything.
I agree with you, Mr. West. So I guess that Google is holding $600,000. Is that, I don't recall that, but is that right?
That is my understanding. They're holding about $600,000. And you issued an order telling, frankly, freezing those monies being sent out to the defendants.
Trust me, they're not sending us any money.
That's right. They're not, because we got an order.
Okay, so you don't.
So the reality is that if we didn't have the order, you would agree. You're a very rational person. If we didn't have the order, they would have sent the money to them. And then it should be
the $600,000.
Guys, okay. What I want you to do is submit me a letter brief as to the amount of damages that are appropriate as to Ms. Bone. I'd like to get, if possible, from Mr. Hurst, the exact amount of money that's being held by Google at this point as to those two channels. Does everyone understand my ruling at this point? I'm ruling in favor of plaintiff on all causes of action against Ms. Bone. I'm ruling that we're discussing the amount of damages, and I've written down all of this stuff. So I'd like to get just a short trial brief with exhibits attached would be great, and a report from Mr. Hurst, if possible, about how much money is being held right now, and try to get that to me as soon as you can. I may need to have another short hearing on this just to discuss the exact amount. Wildcraft and Futuristic Hub will both be transferred. The ownership of that will be finding in favor of the plaintiff on that. Have I missed ruling on anything at this point?
Exemplary damages on the table, Your Honor, also.
Can we include that in our brief?
Yeah, why don't you include a discussion of that? And so, any other questions?
About the house, Your Honor.
Oh, and I'm sorry, I'm going to award $250,000. That's what she got out of it. So $250,000 for the house.
Yeah, there were other there were other sites also, channels, I'm sorry, that like Top Trend. We had asked that they also be paid over.
I thought those were already transferred. Is that? not
No,
right?
they're not, they don't belong to us. They never have.
We asked the Futuristic Hub, Wildcraft, Creamwork, Blocktastic, Top Trends.
Well, 2 of those 5, we have no claim to, so we don't care what happens to them.
All of those will be transferred to the plaintiff.
Mhm.
Thank
And
you.
if there's some other owner, then they'll need to bring it up. So we just include that in the judgment. Provide me a proposed judgment, Mr. West, by next week, and anything else we need to chat about.
When do you want the briefs to you? Like by next week?
It'd be nice to be able to find out from Mr. Hurst. And if we need to, I don't think I could do it next Monday, but the Monday after, if Mr. Hurst is available and he needs to talk to us about this, if he can't just give you the number, then I want to have a discussion with him just about how much all we need to know is how much money is being held in the registry of the court. And I guess the other issue is, what order does Google need from me to transfer ownership of these accounts? What do I need to do exactly to make sure that these accounts get transferred over?
Okay, we'll talk with him.
All right.
Thank
So tentatively, we might meet the Monday after next, unless we can get this done without that. All right. Anything else, guys?
No, Your
We'll
Honor.
get back with the court coordinator on that day.
All right. Thank you. Bye-bye.